ನಡೆಮಡಿಯಾಗದೆ ನುಡಿ ನುಡಿ ಮಡಿಯಾದರೆ ನಯ್ಯ ನಡೆಮಡಿಯಾಗದೆ ನುಡಿ ನುಡಿ ಮಡಿಯಾದರೆ ನಯ್ಯ ಒಳಗೆ ಮಡಿಯಾಗದೆ ಹೊರಗೆ ಮಿಂದರೆ ನಯ್ಯ ಒಳಗೆ ಮಡಿಯಾಗದೆ ಒಳಗೆ ಮಡಿಯಾಗದೆ ಒಳಗೆ ಮಡಿಯಾಗದೆ ಹೊರಗೆ ಮಿಂದರೆ ನಯ್ಯ. ಧನ್ಯವಾದಗಳು. Thank you, Sahitya. I request Ms. Megha Kedia, Assistant Professor of Law, to deliver the welcome address and introduce the dignitaries. Megha.
A very good morning to one and all present here. It is my privilege and honor to extend a warm welcome to everyone gathered here today for this conference organized by KLE Law College, Bengaluru. At a time when technological advancements are rapidly reshaping legal frameworks, institutional practices, and societal structures, deliberations of this nature assume great significance. This conference seeks to bring together academic insight, professional expertise, and practical perspectives to engage meaningfully with these evolving challenges and opportunities. I take immense pleasure in welcoming our esteemed dignitaries to this inaugural session. It is my proud privilege to extend a warm and respectful welcome to our chief guest, Professor Dr. C.S. Patil, Director of the Karnataka Institute for Law and Parliamentary Reform and former Vice Chancellor of Karnataka State Law University, Hubballi. Professor Patil had a distinguished academic career, having taught at multiple colleges across the state of Karnataka. He served as professor at Karnataka State Law University, Hubballi, and held several key positions, including the head of the Research Center for Democracy and Constitutional Government. He has made significant contributions to legal scholarship, having authored a book, edited 2 volumes, and published over 80 research articles in reputed law journals. He was also among one of the experts who submitted a research paper to the Honorable Justice V.S. Malimath Committee on Reforms of the Criminal Justice System. His contributions extend to legislative drafting for the government of Karnataka, including the Karnataka State Human Rights Coach Rules 2006, and he has been recognized for his work in the field of human rights. With over 3 decades of dedicated service in legal education, legal aid, and legal literacy, Professor Patil continues to contribute actively in his present role as director of the Karnataka Institute for Law and Parliamentary Reform. We are deeply honored by your presence, sir, and we extend a heartfelt welcome to you. I now request Dr. Anita MJ to kindly present a sapling to Professor Patil as a token of our respect and appreciation. I extend a very warm welcome to our distinguished guest of honor, Professor Dr. Harpreet Kaur, Vice Chancellor of National Law University, Jodhpur. Professor Kaur is an eminent scholar in corporate and commercial law and has served as Vice Chancellor since September 2023. Prior to this, she held the positions of Professor of Law and Registrar at the National Law University, Delhi. With a distinguished academic career spanning over a decade, she has made significant contributions to the teaching and development of subjects like company law, competition law, and international business law. She is a Fulbright Nehru Scholar and has held several prestigious international academic positions. She also serves as the director of the Center for Corporate Law and Governance. A prolific author and editor, Professor Kaur has published extensively with multiple leading publishers. Her work continues to shape contemporary discourse on corporate governance and regulatory frameworks in India. We are truly honored by your presence, ma'am. Thank you for gracing this occasion. I now have the privilege of welcoming and introducing our next guest of honor, Mr. Karthik Kannappan. Mr. Kannappan was a student at Kelly Law College here in Bengaluru. He is a distinguished global legal professional with over 2 decades of experience in advising multinational corporations. He currently serves as Global General Counsel, Chief Compliance Officer, and Chief Information Security Officer of Indegene Limited. He possesses extensive expertise in corporate governance, regulatory compliance, and risk management. His experience spans the development of global ethics and compliance programs across the United States, Europe, and the Asia Pacific region. He has advised boards and senior leadership on critical strategic matters, led high value negotiations, and handled corporate investigations and regulatory proceedings before authorities such as the US Department of Justice and the Securities and Exchange Commission. We are privileged to have you with us today, sir. I now request Dr. Manoj Kumar Hiremat to kindly present a sapling to Mr. Karthik as a token of our respect and appreciation. I further extend my respectful welcome to our esteemed principal, Professor Dr. J.M. Mallikarjunaiah, whose visionary leadership and constant guidance continue to inspire all of us at KLE Law College. We are deeply grateful for your continued support and encouragement, sir. I request Mr. Naveen Talwar to kindly present a sapling to Principal Sir as a token of our respect and appreciation. With such an illustrious panel of dignitaries, we are confident that today's deliberations will be insightful, enriching, and intellectually stimulating. Once again, I extend a warm welcome to all our guests, participants, and attendees. Thank you.
Thank you, ma'am. May I request the dignitaries on the dais to kindly proceed for ceremonial lighting of the lamp. Please. Thank you, everyone. It is indeed an honor to invite Professor Dr. C.S. Patil, Director, Karnataka Institute for Law and Parliamentary Reform, Kilpar, and former Vice Chancellor, Karnataka State Law University, Hubballi, to deliver the inaugural address. Please, sir.
Good morning. It is always very nice to be back here in KLE, wherein I was an employee for a period of more than 6 years. And this is a place which allowed me to grow as an academician with all the opportunities. I always remain grateful to KLE for that opportunity. The most respected guest of honor, Madam Professor Dr. Harpreet Kaur, Vice Chancellor, NLU Jodhpur. We would have loved to have you here physically, but because this is a conference on digital technology, maybe we are riding on that also as a proof of what is going on. And my young friend, Karthik Kannappan, Vice President, Global General Counsel and Chief Compliance Officer. This is all very strange language to us. And he was discussing so many things. I was just imitating that. I am following and understanding what he speaks. Sometimes we used to have a story in our school. Blind people trying to feel what the elephant is like. Okay, each fellow touches different part of that and he feels it is like this, it is like this. And in the world of technology, artificial intelligence, our position is like that. My good friend, Professor J.M. Mallikarjun, very innovative young principal who has created such wonderful opportunities for all of you students who are grooming yourself in this distinguished institution, learned faculty members, delegates, participants, and my dear students. Always I look at things and wonder, because many of you have not seen the technological development the way we have seen. Starting from that manual typewriter to the electronic typewriter to the dot matrix printer, liquid toner, powder toner. See, veritable things happened in our lifetime. But it was happening in a very slow pace. We could catch up with that. But now suddenly there is a torrent of technology that has flooded. This is a tsunami. And for people of my age and even those people who are younger to me, it has become a challenge, not to accumulate, to survive. It has become a challenge to survive. If we embark upon the discourse in this area, the conference on digital, emerging and exponential technologies, we have to look at the setting. Recently, the Supreme Court of India said, leave India if you cannot follow the Constitution. That was when it was hearing an appeal against the CCI's decision imposing penalty of 213 crores on Meta over the WhatsApp's 2021 consent policy, take it or leave it. I was wonderstruck at the figure, 213 crores. right? The court called this practice, take it or leave it, as a mockery of constitutionalism. So we have a situation wherein a technical giant can mock at the most fundamental document of this country. The court said, what consent it is? It is a manufactured consent. That's why it upheld that decision. And government took a decision to pre-install, what is that? Sanchar Sati in the mobiles that are going to be manufactured in this country. Right? It announced the policy to roll it back immediately. It is not an ordinary individual or the institution, it is the government of India. The national government could not stand by the policy it has announced. It had to roll back because it does not want to lose Apple manufacturing its mobiles in this country. And we have all read in the newspapers, 3 people driving a car, followed GPS, drove on an uncompleted bridge, fell into river and died. Right? They followed that GPS, route map, whatever. And we all, sometimes or the other, have run into problem following the GPS thing. Sometimes it will take to a dead end. Right? And first robotic surgery that was carried out in 2024, laparoscopy hospital, using that Mantra robo. We all looked at it in the news bulletins and we were wonderstruck. What is this happening? Remote robotic surgery. Feels so good to see all that. And a 40-day-old baby was brought in zero traffic from Mangalore to Bangalore in 4 hours, 20 minutes, covering a distance of 360 kilometers. Feels so good. When a child is saved, we feel good. When the commuters fall into river and die, we feel bad. This is the paradoxical situation in which we are. High time. People should start talking, discussing, debating, critically analyzing what is happening around us, what is happening to us. Professor Mallikarjun, congratulations to you for having initiated this debate at this massive scale. We have to look into the legal framework. Where is that frame? Do we have laws which can address these complex situations? In relation to criminal law, we used to say always criminals are one step ahead of the lawmakers. Now these people are miles and miles ahead of the lawmakers. How the system will respond to this technological, what is known as digital revolution. It has affected our lives beyond imagination. At every moment, we are at technological interface. All of us are here, somebody knows that this fellow is speaking, that mobile is listening. And sometimes you also have some experience with all these things installed, that blue circle and everything there. Sometimes I am discussing something with my friend and some pop-up comes. What I am discussing, that is reflected there. Something is forwarded to me. Look, this is what you are looking for. See, this is the thing that is happening. We have all parted with our personal information for all the service providers to complete various transactions. Somebody is applying for scholarship, somebody is booking a ticket, somebody is taking some government services. access to social media, everything. We have go and sit in the family court sometimes. How the society is shattered. Surrounding recordings, couple tracking. All these tech-savvy fellows, they track their spouse. They come to know what they are They are not supposed to come to know certain of the things. So once they come to know, they land up in the family court. Now family courts are 13, 14 family courts in Bangalore. As technological revolution happens, family is at the center of the revolution because of these gadgets that we are using. We have all consented. One of my PhD students is working in this area. And because of her PhD, I am made to read at least 20 consent forms. Sometimes they run into about 50, 60 pages. The shortest consent form will be somewhere around 20 pages. And very difficult to understand. We have consented to all those things. Accept, allow, follow, whatever we have picked that. Okay. By doing this, what has happened? See, all the technological innovations right from beginning, it was used to facilitate life, liberate persons. But this is one technology which has enslaved a person instead of liberating that person. Okay. And these devices, wearables, all those gadgets that we are using, they have made us lose our cognitive process. See, right now, we have to, as students of constitutional law, speak in terms of cognitive autonomy. Having taken birth in this country, wherein all these things are bombarded upon me, wherein my decisional freedom is influenced, my choice is also influenced. What happens to my right of cognitive autonomy? Am I not having freedom to think in this country, or should my thinking process be allowed to be influenced by corporate giant? That is the question. We have DPDP Act and the rules framed thereunder, and we have so many things. When on Facebook I was getting this feedback, 1 year back you did like this, 2 years back you did like this, and this month you have traveled here, and that route back. I was feeling so good. Okay, Facebook is whether Facebook has a right to profile me. Okay. In this country, do I have a right against profiling? Is the question to be addressed. We have to guard our cognitive assets. My choice should not become a casualty, and I should not become a casualty in this dynamic technological era. The problem is, we know how to regulate a human being. We have experience. We have centuries of experience in regulating human beings. But how to regulate an algorithm is a problem. Right? This is a new thing, fast developing. How we have no experience. And we were discussing, there is no time to wait also. There is no time. We have no experience. We have no time also. The problem is, I don't know whether I asked this question when I met LLM students here last, constitutional law in different universities. Wherever I have asked this question, till now I got one person who said, yes, I have done this. Touch your heart and tell me whether you have checked the meaning of this word constitution before you started study of constitutional law. Have you checked English dictionary meaning of constitution? Till now, one person said, sir, before I started my study, I checked what is the meaning of constitution. Now we are speaking of algorithm. We are speaking of big data. We are speaking, at least this person is speaking without knowing what is the algorithm, what is big data. And I am discussing, debating, And when that is the fate of a professor of the university, think of those policymakers who are our elected representatives, assisted by we have to make them understand, evolve appropriate policy, because there is a great shift that is going on in this country. At this juncture, we have to reconsider our basic principles. See, our fundamental rights, constitution, state, definition of state. See, now who is controlling us? Lot of information has moved into the private hands. They have become the major players. Whether my fundamental rights should be available against him also, against this corporate entity also, against this multinational also, or whether it should be confined to the traditional concept of state. This is the situation in which we are. And we are entering a paradoxical world. We are going to fight battles. On one side, we have economic development. On another side, we have job losses. Some people say job loss is good because these people who lose jobs will elevate themselves by acquiring skills. There is no proportion. Because of AI, the quantum of job loss is highly disproportionate when compared to those people who can acquire skills and re-employ themselves. And in a country with so much of population and that low quality education, how we will meet up this challenge is a question. When we were students in master's degree, our teachers were telling us, future wars will be fought for oil. And we are witnessing this war. Okay, now I am reading a book wherein it is stated future war will be fought for data. So this is a competition for data domination between China, USA, and other countries. They want to dominate. And this race for data domination will weaken the sovereignty of the nation, in turn, the sovereignty of the people. And we are going to enter digital colonies. We received East India Company, which could take over all the states which were existing at that time. Now, this fellow, Rajiv Malhotra, says this is like, in the digital world, inviting East India Company with hugs and appreciation. They are going to challenge our sovereignty because they will control the data. And another important crisis situation is battle for psychological control our desires and human agency. Critical thinking, it has gone. In all our PhD thesis, we use this word, critically evaluate, critical appreciation, this word critical has become a casualty because I am not thinking someone else, some other algorithm is thinking. Okay. The type of quest we had for knowledge through ages is not there with now. For example, I am trained how to check value of a precedent using citators and reference citations. I don't know if there are boys or girls here in this auditorium who have touched these citators. You have not seen because you are a modern day law student. I am a product of the library. Sometimes professor says, check whether this case is overruled. I will run to the library, take citator and go on to check the status of a case, how many times it is followed, whether it is referred, appeared in dissenting opinion, distinguished, restricted in comfort, overruled. criticized. For all this, we were using the physical copies of citators and we were making it out. It was taking time. Maybe it was taking around 15 minutes for the purpose of checking and reporting to the teacher as to what is the status of that precedent. But now, Manupatra, you prick that button, you will get bubbles, 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 big bubble, small bubble, small bubble. And color coded. What is overruled, what is followed. See, color coded bubbles you get. When I was interacting with the concerned person from Manupatra, he said, "Oh, you are color coding. This is a thing which will be used by law people." Okay, you can say D, you can say F, followed, distinguished, overruled. No, color coding. See to what extent we will lose our cognitive ability because we will look at, oh, red, overruled. Huh? And the color blind fellow will run into problem with color coding of the precedents. Right? What is happening? This year, 2026, Lucknow University, thesis submitted in January, February, 95% of them are flagged off as plagiarized using AI assisted writings. 95%. Authoritatively declared by the university itself. We have Professor Aital teaching here in this, anything in jurisprudence. We say Professor Aital is an authority. Earlier we were saying Professor Ajappa is an authority. Devarla, Professor Vishweshwaraya is an authority. In another few years, you will not have authorities. We are going to lose authority. Constitutional law, go and consult Anirban, Professor Anirban. No. What is that you said, sir? Something? That software you told. Claude Cowell. That will become authority. Okay. So there will be no individuals who will be authorities in the subjects. There will be no individuals who will be known for their knowledge. Okay. There will be no individuals. So human agency will be replaced, all technological, human psychology. See how data was used to swing votes in the presidential elections. Cambridge Analytica and all that, we have witnessed that. One of the writers, Shoshana Zuboff, I have picked up one para from there. We celebrated the new digital devices as free. But now we see that the surveillance capitalists being those providing those services regard us as free commodity. We thought that we search Google, but now we understand that Google searches us. We assumed that we use social media to connect, but we learned that connection is how social media uses us. We understand that privacy policies are actually surveillance policies written by legal experts. Okay. It is a sort of bloodless coup that has taken place. What we know and what is known about us, this has led to digital capitalism. We are living in an asymmetric world. There is no symmetry between us and these jets. And somewhere here and there, somebody is speaking about that. Some consumer activists, some public activists, and now KLE Law College, Bangalore is also thinking. And it has started a debate. Those 3 girls jumped off and committed suicide, no, because they were feeling Korean style of living. So what is happening? That means the technology has taken total control of these children and their thinking process. There is one Pocket FM. I have it here. Chandragupta Maurya, series of episodes about that. I am not a student of history, but I felt I will learn this. Then I started listening to that. Till now, I have listened to 375 episodes, 20 minutes each. And therein one pop-up comes. See, you have to buy, you have to pay and buy coins and use that. Then for one free episode, view 2 advertisements. So it is money, no? And especially for people of our age, money is very important because money we counted. Not like you, we did not swipe money, we counted money, we carried it in our pocket. So I feel I will save few coins if I watch these 2 advertisements. Right? He is making a person of 64 years of age to watch those advertisements to save some coins. What about the youngsters? What about the poor people? We are made to see things which we are not interested. There is no way they are gaining control over us. And we are compromising our constitutional right. There is an expression in one of the books, the subheading is datafication of human life. So we all become a sort of data. All cameras in public places, surveillance, information collected for various purposes. Monetization of IRCTC floated a tender for 10,000 crores to monetize the customer's data. There was hue and cry. And government withdrew that tender. They said that it was issued by oversight. See, data is so valuable that people are fighting war for that. And in this situation, we have a fragile legal framework, Digital Personal Data Protection Act, and the concerned rules there. There will be expert papers presented wherein you will analyze what are the shortcomings in that area and what are the good aspects. Predictive governance, surveillance state we are running into, privacy is compromised. There are various problems with the different models. Friend was speaking about the risk involved. We have to speak of what you call as accountability, how we are going to fix accountability in this area. And we are speaking nowadays in terms of digital constitutionalism. How we are going to make these organizations, corporate sector, the giants, to comply with the constitutional requirements. Digital power is to be subjected to constitutional injunctions, otherwise constitution will become irrelevant. Money will get concentrated in few hands. Right now, we have all these directive principles, land reforms, social justice. We tried 75 years, nothing big has happened. But in days to come, very quickly, there will be concentration of wealth in very, very few hands. Right now, 90% of the resources of India, riches of India, is owned by 5% of the population. And in days to come, that will be in small numbers who will own all the wealth of this country. Unchecked digital state power also will compromise Article 21, 14, and all these problems will crop up. The tech companies will become quasi-sovereigns. A situation may come wherein states will request these tech companies to help them. That will be threat to democratic process. That will create a lot of problems. And especially at the end of that, Anuradha Bhashin's case, when we say right to internet is a fundamental right, this is a fundamental right, and all those things. There is opacity, there is, see, anonymization of data. There is counter to that. Anonymized data can be used for re-identification. And lot of obligations that we are imposing are on voluntary basis. They are not mandatory. This is the situation in which we have to critically think as to how we are going to cope with this digital onslaught on our private lives. It has walked into every field of life. Human beings are replaced by individuals. Professor Anil Verma was telling after a few years, maybe C.S. Patil is not required. Ask our friend and he will create something which will inaugurate the conference. Okay. Then what about the audience? Put audience also. Make some audience also. He showed us some technology wherein he puts some algorithm on the task of, say, culling out all the information from the mails and process it in the form in which he wants. And that is involved in a dialogue as to what it will do for the purpose of carrying out this command. It talks amongst different things. They talk amongst themselves and ultimately come out with the final product. This is the problem. Startups. One of the startup which was for the purpose of booking burials, it went off so well. So we have good side of it, bad side of it. In between, our lives are involved. And first we have to acquaint ourselves with this change that is happening. And later, at the level of the state, at the level of the nation, we have to think in terms of putting an appropriate policy. Other day, there was a conference on use of artificial intelligence in the court process. The principal is acquainted with the speech that is delivered by our Honorable Law Minister H.K. Patil. Kerala has already put in to service some artificial intelligence in the courtroom. And we also are evolving a policy in that direction. And the Miss India, that girl who was voted Miss India, she said, we have to use artificial intelligence as an assistant. And it should not be a master of what we think. And in courts also, they are going to use it as an assistant, not for the purpose of giving decisions. But we do not know if the decisions of that are going to be superior to the decision of human beings. Human beings may be replaced. Once I was speaking about human rights vis-a-vis police personnel in Chitradurga. One circle inspector who was left with 3 years of service, he said, and I do not want these human rights. With all these things, how I can become a police officer, how I can discharge my responsibility. I will take voluntary retirement because he is not in a position to cope with the human rights jurisprudence. Same is the case with us. We do not want to acquaint with the digital technology. Anyway, I am a retired professor, but because of Mallikarjun sir, I have to acquaint myself with some of the literature. Thanks for the opportunity provided, sir, and thanks for patient hearing. Thank you very much.
Thank you, sir, for your insightful and enriching address. I now request Professor Dr. Harpreet Kaur, Vice Chancellor, National Law University, Jodhpur, to kindly address the gathering. Please, ma'am.
Good morning to everyone, and I hope I am audible to all of you. First of all, my thanks to the principal, Professor Mallikarjun Ayya, for giving me this opportunity to be associated with KLE Law College. I was supposed to be there, as Professor Patil has said, that we would have liked you to be here in physical sense, not in the digital sense, not virtually. And I was prepared to come there, but the Jodhpur airport is under renovation, and that's why I was not able to be there physically. And going to Jaipur, 5 hours from Jodhpur by road, and then 2 hours of flight, and then God knows, Bangalore's traffic. So I thought that it's better that I speak from here. And anyway, the conference was on digital, and emerging and potential exponential technologies only. I would also like to give my wishes to Professor Patil, who is the chief guest, and Mr. Karthik Kanappan, who is the guest of honor. And there are assistant professors who are involved, Ms. Megha Kedia and also Mr. Tanmay Patil, along with Sahitya and Raksha. So my thanks to all of you for arranging this inaugural session. Since the theme has been on law, algorithm, and accountability, governance of artificial intelligence and machine learning in critical sectors, I thought I would touch upon usage of AI and technology in corporate governance, because that's my area, and how it is helping in decision making in corporate law. Then briefly, I will discuss about the usage of AI in judicial system. Coming back to then briefly about the debate which is going on between global north and global south when it comes to AI and other technologies. There was one statement 2 years, 3 years back made by one of the former head of Google Brain, who said that artificial intelligence is the new electricity, and which can illuminate the dark tunnel of corporate decision making, and also the governance worldwide, and can offer innovative solutions to long-standing challenges of the corporate sector. And looking into that, I thought that because I keep on updating myself into this area, I keep on looking at the different reports which are published by different commissions. So in 2024, I looked at the European Commission's report, and which report is already present already there on their website. That in that report, they said that 13% of the respondent EU companies, which were part of that survey, they were already using AI in their corporate boardrooms. And when I looked at for the present presentation, that what is the data available, it says that now approximately 20% companies with 10 or more employees, by end of 2025, they are using AI. And there is there is an evidence that there is direct usage of AI for high level of strategic decision making. This has been reported, and 40% large cap companies in Europe, they are having AI policy, formal AI policies. Then there was one survey which was done by World Economic Forum, and they had said that by 2026, this survey was made in 2015, and it was predicted that by 2026, that corporate governance would have faced a robotization process of a massive scale. And we still have to see, because survey has to be again conducted. We are in 2026. And there was another survey conducted by Global Agenda Council of World's Economic Forum only. And they had said that more than half of the respondents expect that AI will be used by their boards by the end of 2025. And still the data is not available whether by end of 2025 what is the position. But there is a new prediction which has been given by World Economic Forum. It says that agentic AI will become mainstream in boardrooms in 2026 in EU, and which definitely will have to be assessed in the year 2027. And if we look into India, SEBI, Securities and Exchange Board of India, is also encouraging that we should use AI for the market surveillance and fraud detection when it comes to companies and the securities market. Right? So why there has been so much of AI usage and technology usage? That's the question. This is because there are demands of corporate governance, and we say that we should have more security, transparency, efficiency, and also decentralization of the process. And because of that, the companies' boards, they were driven towards usage of blockchain and the AI. And because these technologies, they empower companies to to adapt swiftly to the changes, address challenges, and also enhance efficiency of their operations. And they say that it's not just about the compliance, but it's also about the smarter decision making and fair treatment. Now, how far this has been there, we have to definitely look into. If I take an example of the closest example that how autonomous AI has been used in the boardrooms, one example that comes to us is Vital, which is validating investment tool for advancing life sciences. And this was an AI algorithm which was used on the board of directors of a company, Deep Knowledge, which is a Hong Kong-based capital venture firm. And it could decide whether to invest or not, and had actually approved two investment decisions to fund In Silico Medicine and Pathway Pharmaceuticals for this investment company. But then initially it was said that it's one of the board members, but then because Hong Kong law and regulations, they did not allow any artificial person to be a board member because it has to be a natural person. It was reported that it is treated as an observer by the other human members rather than an actual member of the board, right? Now comes the question that what is the benefit of blockchain technology? So definitely it enhances transparency of ownership in the companies, and which can help in shareholder activism and can curb insider trading, maybe accelerate securities trading also, and also the settlement processes, because settlement processes in the securities market, they are, they have an impact on the liquidity in the market. So improved liquidity and settlement processes, if they are quickly done, definitely helps the system. And also it secures identity verification, tamper-proof, voting, which are essential for maintaining the integrity of the corporate governance. And it safeguards the voting process, and the concerns which are raised about fraud or manipulation in the voting can also be taken care of. So how they are, helping. So the blockchain, along with the artificial intelligence, is automating the data collection. It is sharing and processing the data in order to create so-called transparency, straightforwardness, and efficiency in the operations. And besides that, it's also said that the machine learning helps in decoding patterns and anomalies, identifying potential risks for the fraudulent activities, and companies can preempt such kind of fraudulent activities. And so therefore, immediate action can be taken up, and issues can be prevented before they get escalated, right? So therefore, the transparency and encryption, these features, they are helping businesses to meet the strict data security rules, protecting sensitive customer information and also the company information, because they have secure auditable records of the data access and the transactions. But there is a caveat. The caveat, we all have known about the black box phenomenon, and lot of information and discussion is going on that because of the processual opacity of the black box, and people and the users, they are not able to apprise themselves of the key information on the basis of which it is working and coming to a certain decision. But from a corporate liability point of view and consumer protection point of view, I want to raise this point that because of the technical nature or the access is not provided to a citizen who is harmed by AI system, to prove that there is a defect, we have to come out with something in order to take care of this situation. So there has to be procedural justice, and probably we may come up with introduction of rebutable presumptions, and which means that burden should shift to the technology provider to prove that their system was safe, rather than forcing the victim to prove that the system was flawed. And when it comes to consumer rights, we also need to tackle dark patterns, which are design choices that trick the consumers into decision making that it did not intend to make. And so when it comes to, as Professor Patil was reiterating multiple times, that we have to protect ourselves as a consumers also. And today in this digital age, I think every one of us who is using technology for buying processes, we have become a vulnerable consumer. So we have to target, dark patterns, and we have to maintain, subvert consumer autonomy, and that the points that uphold the ethical right to autonomy in decision making, and also right to make decisions which are free from manipulative machine designs. So the challenge is that that we want to ensure speed and efficiency, but it should not come at the cost of the accountability and the trust. Now, there are certain questions that I have raised where students can look into it. Coming to the judicial system, we can, I think, categorize AI application in judicial system in three categories. One is AI application in e-courts. Another is AI usage for legal translation and language accessibility. And then AI in law enforcement and crime prevention, which is the most important aspect because it is helping in predictive policing, surveillance, investigation, FIR filing, and judicial proceedings, and also helping in data-driven crime tracking and intelligence systems, preparing that where criminal mapping can be done and factor analysis can be done through the facial recognition, accuracy enhancement. These are the benefits which have been given. Right. So here we have to see that, where AI is enabling predictions for a more proactive justice system by enabling predictive analytics, where AI is analyzing historical data to identify patterns and forecast potential events. This is beneficial, no doubt about it. But then we have also see that, what is the likelihood that the individuals they become victims or re-engage in the similar criminal conduct in the future? Can such kind of predictive policing can help us? Can it help in supporting decisions on bail? And for example, recently two of the high courts, they have already decided that they will not permit usage of AI in the decision making writing. And also they have not categorically said about predictive analysis, but they have said that where AI will be used and where it cannot be used. So we have to be careful about it. So when we say that these are the benefits, the question is that what are the challenges that we have? So there are few important challenges that I would like to raise here. First is the challenge to the traditional legal notions, because increased use of AI definitely, when we are using to predict human behavior, more specifically criminal behavior, it is also challenging some of the traditional legal notions. So one legal notion is that an accused, before being proven guilty, has to be regarded as an innocent. That's a legal notion that we follow. And if we are using the algorithmic risk assessment in the criminal trials in order to determine recidivism, it raises the question of whether the accused is deemed guilty of a potential crime, that is the propensity to commit a crime before it has actually occurred. So another challenge is that the traditional view of rule of law is the extent to which judiciary relying on AI developed by private corporations can be deemed independent. I think this is also one of the very critical points, that again it relates to the data also, that these softwares are developed by private corporations. So before we say that AI can assist in the rule of law, we have to probably look into these 2 points very well. Then the second challenge is about building public trust in AI. And so there has to be certain sorts of balances, checks and balances, or some sort of pre-existing governance mechanism, where we can say that autonomy of the judiciary is maintained. Probably this is also one of the reasons that the high courts, two high courts, they have come forward for restriction on using of AI. Right. So the responsible AI adoption definitely requires a strong data security. It requires legal reforms. It requires transparency to ensure that it supports rather than replaces human judgment in judicial processes. I think, again, this goes to what Professor Patil has said, that whether humans will be replaced. But what point I'm saying here is that the approach has to be human-centered, the next point which I will be elaborating upon. But we can't think of replacing human judgment when it comes to judicial processes. So there has to be a lot of government investment, sustained government investment and regulatory oversight if AI has to be used in the judicial system to make it faster, more accessible and transparent to all the citizens. Coming to the third challenge of ensuring human-centered approach, and we know that the potential requires a human-centered approach because it promotes digital transformation, and it is supposed to protect human rights, right? Even in the digital age, protection of human rights is the fundamental, right? So we need to have human-centered approach, ensure human-centered approach in judicial decision making, which is through the AI system. So there is requirement of effective governance involving all the policymakers, legal professionals, and technologists to align AI applications with the principles of fairness, equity, good conscience, and also procedural integrity. So, continuous impact assessments are required, stakeholder engagement is required, mechanisms to redress both the legitimacy and effectiveness is required. So this is, I think, these are the designs oriented, requirements when if we want to use for decision making. Then coming to the challenges to ensure algorithmic transparency and algorithmic transparency, we have from corporate law, I can say that price fixation from competition point of view, price fixation, or deciding on the prices, the kind of collusion which is possible because of the algorithms. So the transparency is required, and when this comes to the judicial system, that means that it will definitely have an impact on explainability of the judicial decisions, because if AI systems are not transparent, it would be challenging to know the rationale of the decisions, understand the rationale of the decisions. And therefore, as I said earlier, that this opacity can result in difficulty in challenging and ensuring fairness of the decisions, leading to a lot of distress on the use of the tools and ultimately on the judicial system. So it's not only required for ethical reasons, but also required for meeting the legal requirements of the due process also. And these ethical considerations should extend to all the stakeholders, including defendants, victims, legal professionals, and society at large. So there are certain questions which legal system will have to answer. For example, how to add strategic value to the time saving or the efficiency point. Then how do we regulate rapidly evolving technologies without stifling innovation? How do we manage associated risk and implementational challenges? Associated risks will be definitely inadequate or skewed data in the AI systems, lack of transparency, explainability, inaccuracy of data, falsehood and unreliability, and also over reliance on AI. There will be implementation challenges also, because we do not have high quality data or ability to share it, and there will be definitely skill gaps. Now coming to the last point that I want to raise about global north and south debate, though there are number of points, but I thought I will keep myself limited to a few points. So the AI systems are designed in one jurisdiction, trained on data from many jurisdictions, deployed globally, and causing harm at some of the countries we do not know where they are causing harm. So, whereas if we look into the liability framework, our traditional liability frameworks are territorial, right? And whereas AI harms, they are transnational and they are diffused. So we need to definitely have AI, liability system where the governments are definitely working on it. We know about it. So, for example, if we go to the model developers, and their defense will be in the form of claiming safe harbor, that okay, we are a neutral platform for providing AI tools. That's the first defense. Then providers, they come with the defense that they are only the infrastructure providers. So we do not control how the compute is used by the users. Social platforms, they claim that they have removed the content once it was flagged, right? Because we are not the editors. Actual manipulators, they operate from jurisdictions which have weaker enforcement or weaker extradition mechanisms, right? So how do we deal with such kind of defenses which are, ready to use defenses? And we have seen also such defenses being used. So can we go for open source models which have, which can establish a causal chain from model creator to the deployer to the harmful output? I think presently it is nearly impossible, the readings that I have done. And when the harm occurs, the companies, they claim that users had misused the technology. It was not intended for example, medical diagnostics. So if a doctor has used or AIMS has used, they'll say that technology has been misused because it was never intended to be used for medical diagnosis. Local deployers, they should have validated, you should have, for example, tested the technology for Indian conditions before using it. And there are harms which were unforeseeable because we could see only the foreseeable harms when we understood the context, but there will be unforeseeable harms. So there is a criticism which says that these kind of discussions, they lead to liability colonialism, which means that profits accrue to global north companies, and whereas harms are externalized to southern populations. So these are some of the points I thought I should bring on the forum, that we are working at National Law University Jodhpur. I should also inform all of you that we are taking a lead when it comes to law technology interface. We are running courses here and doing a lot of stakeholder consultations, from vulnerability of elderly people to the children, all these kind of technology usage, and coming up with the protective kind of guidelines that we are working with the state also here. At the end, I thank once again the principal sir, Professor Patil, and also the other guest of honor, and all other students and the faculty members who listened to me. I do hope that they were my some my speech meant some sense there, that what are the questions and the challenges that we have. And being a professor of corporate law and looking into competition issues, and now going into technology sphere, I think it is interesting, but at the same time it's very fearful. uh, you know uh, I would say the path that we are charting and chalking also. So along with the guardrails are not going to work here. We need definitely strong legislation, not the fragmented legislation that we have at present. I think we'll be using technology for the sake of humanity. Thank you so much. Thank you.
Thank you, ma'am, for your valuable and thought-provoking address. I now invite Mr. Karthik Kannappan, Global General Counsel and Chief Compliance Officer, Indigene, Bengaluru, to address the gathering. Please, sir.
Okay, cool.
Hello. I can hear. I can hear. Very good afternoon. It's not noon yet. So, one of the good things today is that I'm having an opportunity to meet young minds. So, let me quickly introduce. I know that there is a lot been spoken about what I do for a profession, right? But I'm a student, continue to be a student of KLE College. I passed out in the year 2006. And I've been in this field for almost 20 years. What if I tell you, if you can pay attention for the next 20 minutes, you probably are going to be finding answers that can make you readily employable in the next 45 minutes. Would you guys be interested? So whoever are looking into the phone, you can put it down and let's start. First of all, thank you so much, Mr. Mallikarjun sir, for inviting me for this wonderful occasion. And our chief guest, Dr. Professor C.S. Patil, and guest of honor, Harpreet Kaur. So principal asked me, do you know Mr. Patil sir? I said, like, who will not? Right? And today, after hearing the speech of both distinguished guests, I feel a little bit more nervous whether I can do justice to this. I'll make an attempt. Okay, so let's start with a little, let's keep it more engaging and interacting. Okay, so I'm not used to standing before the podium, but I'm still going to try. You guys are aware about attorney-client privilege? How many of you people are aware? We can wake some people from the corner. Anybody is aware about the attorney-client privilege? Have you heard of it? No? Anybody? Madam? Attorney-client privilege? Okay, so let me tell. So whenever a client is coming and talking to you as a counsel, right? They are free to share any information. Any information that they share with you is in the context of receiving a legal advice. So you as a lawyer, listen to their problem. That's called as client counseling as well, right? Many of you guys have already been part of the client counseling sessions. I believe many of you are first year students, right? How many are 3-year students? I mean, 3-year batch? The rest all are 5 years? Okay, so this is going to be very interesting to listen. So recently I was reading, somebody had went to the ChatGPT and searched for how to protect themselves after having committed a crime. Right? He wrote, these are the things I did. What are the legal ways in which I can protect? What are the citation? What's the case law? And then he takes a printout of it and then gives it to his counsel. Now, do you think that this qualifies for an attorney-client privilege? Come on, guys. If you guys are aspiring to be in corporate, you have to be vocal. No? Why? AI has advised, right? And one of that is a very interesting fact is because most of the times you find people asking for some things which they shouldn't be asking with the ChatGPT. And you know why? They keep track of all those records. And those records do not qualify for an attorney-client privilege. And tomorrow, at least in the US jurisdiction, they can issue called a subpoena. They can send a notice to ChatGPT and tell like any other any conversations chat that this guy for this reference period, you need to submit a copy of that. You can't even claim that I've actually shared it with the counsel, so it needs to qualify. Right? So there are usage good, there are usage that is bad. For lawyers, we are still in the middle, figuring it out what's the right way to use it. Okay, coming to the theme today. We are here to discuss about a topic which is no longer theoretical. It's operational, it is embedded, and increasingly it's deciding the outcomes that affects the human life. Artificial intelligence is no longer a peripheral tool. It is now co-authoring decisions, right? I'm sure that many of you are made ChatGPT as the co-author. You guys have been writing articles, research papers with ChatGPT or many other tools that is available. But let's take a step back and see. So what's the real question here? Is it whether I should be using the AI? That question, I think, is pretty much resolved. Today, there is no opportunity where you cannot stay away from using of the AI. So the real question is what? The real question is, who is accountable when the AI is wrong? What does wrong mean in algorithmic terms? Right? Let's frame some of the core issues related to this, particularly from the healthcare sector. See, I come from a healthcare background, so I was a group deputy general counsel and chief of compliance officer in Biocon. Have you guys heard of the company called Biocon? It's a Bangalore-based company led by one of the richest women in the country, Kiran Mazumdar. And if you look at the process of it, right? First thing is that how many of you people are aware about how the drug is being manufactured? Anybody have any idea? Okay, let me ask this. From the time a drug is discovered all the way coming to the doctors where the prescription is being written, how much time do you think it's going to take? Take a guess. I make sure in my sessions nobody sleeps. I'll point out. That yellow shirt. There are two yellows. You figure out which one. Okay, take a guess. How many years do you think it takes for a drug to from the molecule to be manufactured and come in? 2 or 3 years. Anybody think that answer is wrong? From this side, we'll go to the white shirt right there. Yeah, the big. Come on. What do you think? 3 years is going to take? Did you understand the question? No. Can I repeat it? Okay, fine. How many years does it take for a molecule from being discovered to actually becoming a drug? How many years do you think it will take? Say it again. Can somebody help me? 5 years? 4. Okay. So he says it takes 4 years. It takes 3 years, right? What if I tell you, let's take a simple example so that we make it interesting and relevant, right? Let's say you have this, let's say you have discovered a fish. Horseshoe crab. Have you guys heard of horseshoe crab? What's the color of the horseshoe crab's blood? Blue, right? The moment something is different than red, we think something is magical about it. Let's say, for example, these people go and figure out, okay, let's figure out why this is blue, why it's not red, right? And let's say they extract the blood. And then they quickly figure out, they do all this testing. This is called as a preclinical trial. They do all the lab testing. They figure out that there is a molecule that is there in this blue blood that attaches itself to a particular receptor of a virus. Right? Have you guys felt every time you wear a white shirt, you always spill? Right? Why is that? That's how it is. Okay. So let's say, for example, there is a molecule in the horseshoe crab that attaches to the receptor of this particular virus, and then that has a property to illuminate. Okay. Now, what is the possible therapeutical area we can use this drug for? If, say, somebody is suspecting this infected with this virus, I can actually inject this molecule. It travels through the body, attaches itself to this particular virus. Subsequently, when I extract the blood and then I illuminate, I keep it under an illuminating surface, If it illuminates, it's a proof that the virus exists, correct? That's called as detection. And then there are diagnosis. And then there are preventive. And then there are cure. So there are various stages how a drug can be used, right? Now you found out that, okay, this particular attaches itself to the receptor. Now it has got a therapeutical value. What is therapeutical value? I can now use this to check out if anybody is coming for, say, if there is a virus test. I will administer, I'll take the blood, I'll check and I'll say, okay, fine, you have it, right? So this is detection, diagnosis, it helps. Now, once it happens, you also need to figure out if there is any other consequences, right? Sometimes you end up finding something which is more harmful, right? So they take that particular molecule, they do these lab tests outside of any other human or any animal, then they call it as preclinical trial. Preclinical trial is nothing but they'll identify an animal, right? It could be a pig, it could be monkey, it could be chimpanzee, orangutan, a guinea pig, it could be any animal, right? Then they will administer this particular molecule into that animal and then they will check whether it is developing any adverse reaction. Once they figure out that there is no adverse reaction, then they will conduct this study and then they will apply for the license to administer it to a human. That's when the human trial starts. There are phase 1, 2 and 3, right? So they first administer the drug or the molecule in the human and then they will wait to see whether are there any adverse reaction. No, the way it's fascinating to know how the testing also happens. First thing, you know what they will do? They will not look for efficiency, they will look for safety. Efficacy is not the question at that point in time. First of all, is this drug even safe? So what they will do once when they administer, right? They will keep increasing the dosage little by little by little by little by little. Suddenly until somebody shows some adverse reaction. Maybe he got fits or maybe he's continuously puking, he's developing fever. Then they know something is wrong. You know what they do? They'll take away that one person, they'll add 2 more persons. And they'll keep increasing the dosage. Until 2 people show the adverse reaction, the test continues. After that, they will go for stage 2. Stage 2 trial is basically PK/PD study. That is how the body reacts to the drug and how the drug reacts to the body. How it is administered, how it travels through the body. You guys have heard, right? If you have a tablet you have not taken, the next day you take 2 tablets. We all have somebody in the family, right? The night you are supposed to take the drug, but you didn't take the drug. The morning you'll say, okay, I'll take that as well. The reason why that is not allowed is because it can lead to a dosage, higher dosage, right? So they do all this study and then if it is proving to be fine, then they'll take it to the next stage, what is called as the 3rd stage, where they will have a mass people. Like say, for example, all of you guys can be a part of a trial. I'll split the group into 2 or rather 3. One group I will give what is the current drug that is already there. The other group I will give the drug which is being tested. The other group will not be given any of those drugs. They'll be given what you call as a I'm forgetting the name. Okay, so they will give you, this is not a drug, there is no theoretical value at all, right? And then they will test it. How many of you times have you guys felt severe fever? The moment you go to the hospital, you are fine. Have you guys experienced those things? That is called as placebo effect. Okay, so one section I've given the drug that is already there, that is proved. The other drug I've given the drug which I'm testing, the other one is placebo, right? That means if the drug is really working, the one that I have given that I'm testing should actually give me results. They will do the test. After that, they will file for the regulation, they will file for the research paper, all of those things, and finally it comes, you know how much time it takes? It takes 20 years. Are you guys surprised? Now, coming to this topic, Imagine if all of those things can be sequentially squeezed to artificially stimulate the entire life cycle in 2 hours. Do you think it's possible? It's possible, but you don't have a real data to prove, right? That is where it becomes very, very critical for us to understand. Tomorrow, if something goes wrong with this drug, which is basically in, you know, in test trials and all, it worked perfectly fine. The stimulation, you see those video games, you see the movies, right? They'll inject some drug and then suddenly the rat becomes a human. After multiple attempts, they do the genome sequence. Now, all of those things is currently possible. In fact, the pharma companies are also using this technology to figure out, this is my approved medication. I can use it for, say, diabetes. Now, the system and the AI is now capable of telling to these pharma companies, you know what? Diabetes is an autoimmune disease. That means any virus that attacks your defense system, leading to autoimmune disease. All of those diseases, probably you can actually sell this drug to them, right? But this never happened in the real world testing. This purely only happened in the lab in front of a computer. Now that's the level of intelligence that we have got it into. Now we are grappling with how do we use this information and how do you explain this? Let's talk about some of the core issues. At the heart of this theme line, at one side, using of the AI technologies, right? We have speed, we have scale, we have predictive capability. Understand the fact it's only a predictive capability. On the other hand, we have a traditional due process, explainability, and human dignity. AI system optimized for outcomes. The legal system is optimized for fairness, rights, and accountability. These two logics naturally never aligned with each other, right? So when the law was made, the AI as a concept did not exist. Today, the usage of AI is there in every nook and corner. The law is playing catch up. Now that brings us focus to the healthcare in specific. AI today can detect disease earlier than clinicians. It can predict deterioration. It can recommend treatment pathways with statistical precision. When we do this clinical trial, right, there are two ways to look at it. One is actually going and conducting the clinical trial, which I spoke about. The other one is you don't do that study at all. They do a secondary study. They go and look back all the patients who have been administered a certain drug. Just looking at the data, they will figure out whether there is an efficacy, it's working, danger, things like that. That used to take so much of time. But today with this AI intervention, they can go back and look at the data of even 1 million people in a matter of hours. That's what I'm telling. We have a predictive power has been put up, but can it be really tested? Can a human life can rely on that? That's still questionable. Every decision in healthcare carries three important things: duty of care, standard of negligence, and informed consent. Let's just spend a minute about informed consent. How many of you people have consented to Facebook terms and conditions? How many of you people have Facebook account? Nobody has Facebook account? Facebook is for older people now, is it? I'm not able to hear it. So what's the latest one? Instagram. Have you realized if you start liking some poor people, I mean, any post that supports like there's some poor people, the next third recommendations is poor, right? And particularly if you see night times, all the emotional videos will start coming, right? I don't know, sometimes at this stage you can have breakups, But if you are going through something like that, please do not watch Instagram, particularly after 9:30. It will take you so deep. The next day, you will think that I am a completely new person. But imagine the same algorithm is also knowing who's your partner and is pushing similar ad to them also. Right? So where is the consent? Did you consent that, okay, fine, if I start looking at this, uh, some support, next, third, fifth, sixth, eighth, it keeps coming, right? And have you guys figured out that, have you realized that then you cannot go back and actually figure out and say, how do I change it? Have you been stuck in this cycle that once you have started liking one post, or if you spend 5 seconds extra in one post, the next 100 posts will only be that? You know what is the logic? How do you break it? You randomly start liking some other photos. You confuse if you can't get the clear answer. Then the AI gets confused. Now come, let's talk about some serious matters, right? The key challenge number one is accountability gap. When the AI system produce harms, who is liable? Who is liable? You know what? Interestingly, I've just found out a case where we are doing this patient support program. The people who cannot afford to pay expensive ones, the pharma companies have a patient support program. What does it mean? You have to buy one drug, one vial. If you buy one, then the pharma company will give you another 5 vials free. Or they'll say, you buy 4 vials, 5 vials free. And you know what? They are giving only typically to the chronic patients. That means the person may die before even you give the third dosage. Right? And I've just got a very scary situation where they said somewhere something has gone wrong. The distributor has delivered a wrong drug and the wrong drug was administered into the patient's bum. I'm just sitting here and figuring out how is it even possible. Okay, fine, the distributor made a mess. But do you think the doctor should have administered the wrong drug? Anybody have any doctor colleagues, doctor friends, anybody who's studying? You have? Anybody from that side? Anybody who have also tried to become a doctor but failed, become a lawyer? Okay, good. So now in this situation, who is accountable? Is it the doctor? Is it the hospital? Or is it the distributor? Nobody knows. But in the AI, it is even more confusing because we have two more elements. Is it the doctor? Is it the hospital? Is it the developer or the data? The last two is what is very, very critical, right? And I'll tell you an example of how the developers can be accountable and how developers get away with it as well. So I was working on an interesting project. This is about for the people who are diabetic patients. You have a tool that sits in your phone. Every time when it keeps monitoring and then it will tell you what is the dosage that you need to take. Insulin, right? So insulin is the drug. How many of people are insulin? I don't know. I keep talking about various things, but it's important that you understand it. So when you eat something, you digest it, sugar gets released. The sugar needs to actually go into cell for the cell, right? Only then you will grow. But for the cell, for the sugar to get inside the cell has to open. Imagine it's like a lock. The insulin is like the key. So the body, once you digest it, the body secretes the insulin. The insulin goes and attaches with the cell. And then it says knock, knock, open. And then it opens and then the sugar goes in. And that's how the life cycle continues. So we had an interesting case where we've come up with a software that actually tells, depending on what is your sugar reading today, and it has the data of what was the last night's dosage and whether that dosage is working or not. It will tell you now you need to take higher dosage or lower dosage. Then there was an adverse event that got reported. Many people fainted and fell because there was sugar levels dropped so low. When we went back and checked why this happened, it all pointed to that particular software. It is not even artificial intelligence. Understand the fact. It's supposed to look at the sugar levels. It's supposed to look at the dosage, and it's supposed to tell that dosage did not work because you have more sugar floating around. So you go and take more dosage of insulin. That's how it's supposed to do. Many people fell down. Some people got seriously injured. Then we went back and looked at the data. You know who are the people who actually fell ill? Are the same people who did not upgrade the software. Right? Anytime when you go to a Google Pay or a Paytm, it gives you a pop-up, right? You have a newer version. Right? You need to approve. And how many of you people always said that, push it, I'll do it later? How many people have done do it later? That side, back side is very low. I will walk and come there. Anybody have done? Okay, cool. Now, in normal context of it, GPA doesn't make much of a sense to me for me to immediately do. But in this current context, because I did not upgrade, the product did not, the software was not calibrated. When I go to this product owner, you know what they say? The operating system upgraded. Right? I have done my duty to give an upgraded version that is compatible. But the user did not upgrade it. Now here, who is responsible? Is it the person who built the software, who gave the update, right? Or the person who actually did fail to install and update one? You know where it came to? The product owner is still accountable. He should not have let the persons use that at all unless he is upgrading. You understood my point, right? It's a very classic case. Had that product manufacturer put in a code saying that no, if you do not upgrade, the latest version is available until you upgrade it, you cannot use this. Those people would have been saved. You hear what I'm talking about? Now that's the level of depth that one has to go through. I'm conscious about the time. I'll quickly talk about the 3 more key challenges. Explainability. All of you are answerable, and you have to explain any marks that you've got to your parents, right? Is it possible for you to say AI did not help me? That's not an explanation your parents will accept. Imagine that many AI systems are black boxes. Particularly in the healthcare, black box approach is not acceptable. Patients have the right to know why this diagnosis, why this treatment. Doctors must defend their decisions in the court. If the AI cannot be explained, it cannot be legally justified. Right? Sometimes you ask very random question, it gives you a wonderful result, but unfortunately you don't even understand the results. We go back and say like, I didn't understand this, can you please explain to me? Can you please explain to me? Then it comes to the point I say like, okay, fine. Crisp 5-year-old kid, explain to me. Then it gives you that information. Audit trails are very, very important. The life critical systems cannot perform and cannot override explainability. That means the AI systems that is particularly used in critical services, it needs to have audit trails. It needs to have done an impact assessment. It should have a clinical grade documentation to trace back. The third important point is bias. AI is reflective of its data that it is trained. Do you guys know the case where a very multi-billion-dollar company introduced AI in screening the resumes before it offered, shortlisting of the candidates who applied? AI did a fantastic job, by the way. But then quickly they realized it was selecting only men. It was not prioritizing women as a eligible candidate. And you know why? The data that it got trained, the significant portion of the people's database was men. That's the kind of a bias. So you might think you got the best candidate, but somewhere else, a bias is under play. That's not possible and that's not permitted in healthcare. In healthcare, it means unequal diagnosis, discriminatory care, reinforced inequality. There is this famous Will Smith movie, right? Where this bot will be posed with a very critical questions whether it needs to make a decision whether it needs to save Will Smith or the child. Anybody recollect what's the name of that? Sorry? iRobot. I remember. iRobot is a movie came long time ago where Will Smith, another child, is drowning. This bot jumps into the water. It saves Will Smith as opposed to that the child. And the logic was, it predicted that he has better chance of survival, and a percentage more than the child. And the movie concludes saying that 1% chance was still a chance that should have been given to the child and not to this man. But that decision is taken by the bot. Today, every decisions are taken by the bot. You just do not know. Now that's a technical flaw. Consent is a big scam. And I'll tell you why. Today we were just working about this Claude co-work. First time when I saw that, right, I was quite amazed. So I'll just explain in a minute. I went to this Claude co-work, and then it's accessible in your Copilot. I searched and said, like, go through my emails in the last 4 months, pull out all the cases, all the issues, give me the summary of it. It went, but there was just thinking. I was wondering, what is it thinking? I clicked on it. You know what? You won't even believe it. It was actually talking to itself. The user wants this, user wants that. It started planning. Okay, I'll create a bot that will do this. And then there is a conflict between those two bots. I can see, I can read it. All the data cannot be put in the Word document because it will be too much. Okay, let me put it in the Excel sheet. It is creating its own conflict. It has built a bot that can source. It has built a bot that can do the analysis. It's built a bot that can put it in Excel sheet. It has built a bot that can beautify it. And then the results comes to me in less than 2 minutes. It's thinking. Right? Now, think about it. You have given a consent. Informed consent is what? You need to be told what is the purpose, why that data is going to be used, right? But here we have stepped into the stage where the bots are deciding what is the right rationale to use that data for. That means that the purpose is constantly evolving, that some bots are deciding what's the best way to use. That means what? Today, what consent you give is no longer valid. The consent is going to keep changing. Do any of them think about that? Nobody thinks about it. I will quickly conclude with this. India's legal system, in my assessment, is not fully equipped for an AI-driven clinical risk. The existing frameworks like Indian Medical Council regulations, the traditional negligence law assumes human decision making. They do not address algorithm-driven outcomes. The Digital Personal Data Protection Act creates the baseline, but it fundamentally does not cover algorithmic accountability, explainability, and risk classification. So what is required? What is required is not an incremental change. We must move towards a risk-based classification. There needs to be a mandatory audit that needs to be implemented. There needs to be a clear liability allocations, the example I spoke about, right? And enforceable patient right, including dynamic consent. And I hope in healthcare, the real question is not can the machine decide? Always remember, it is can that decision be justified to the patient, to the society, or to the law? With that thought, I have given you enough food for thoughts. If you look into these directions and try to find answers, you are the hot cake for the pharma and healthcare sector. With that, I would thank everybody, organizers, and for your patience in giving me this opportunity. Thank you. And by the way, whoever done this AI work doesn't look like me. Oh, that's why.
Thank you, sir, for such a insightful remarks and valuable perspectives. I request Professor Dr. J.M. Mallikarjunaya, Dean, Faculty of Law, Kale Technological University, Principal.
Thank you. Thank you very much. Well, Honorable Chief Guest of today's program, Professor Dr. C.S. Patil, most respected Vice Chancellor, Professor Dr. Harpreet Kaur, Madam, my dear and proud student, Mr. Karthik Kannappan, delegates, dear students and colleagues. We are running late by 50 minutes for the next session. I will reserve my thoughts to be shared on this topic for some other occasion. But I only have an appeal to make, and with that, I'll be concluding my talk. So the appeal is this. There are two appeals. I often speak of finding an opportunity in adversity. Having been retained, detained, refrained for about a couple of hours in this hall, if you see that as an adversity, better see an opportunity in that. You seldom get a chance to listen to speakers like this. You seldom get a chance to force yourself to sit through and learn inevitably. That chance is brought to you. Please make best use of that. That's the first appeal. The second appeal, you see, we are not gathered here to talk something of legal philosophies, jurisprudential thoughts, constitutionalism, which you guys, to start with, unfortunately think are irrelevant. However, what is being spoken about for these 2 days from now is the governance of AI, which has come to occupy every walk of our lives, which you are going to be, your career, your life is going to be full of application of this. It's just not only damn relevant, it is inevitable for you to sit through and understand. We have very carefully chosen few of the important areas like AI governance in healthcare, automobile governance, and fintech, though the governance has to come through all other walks. These are the important ones for the time being we have chosen, and there are very with good thought, we have selected industry professionals, advocates, scholars. Say, for example, in the coming session, you have two of the personalities from Baikan. You have a greatest legal scholar turned advocate who will bring in newer perspectives. So the appeal is, please do participate in good number in the forthcoming sessions and be the beneficiaries of this very humble but sure attempt, which we are bringing to you to introduce the iceberg of the ocean. Thank you. Thank you very much, and wish you a very happy learning experience. Thank you.
Thank you, sir, for your guiding words. I request Mr. Tanmay J. Patil, Assistant Professor of Law, to deliver the vote of thanks.
Respected dignitaries on the dais, distinguished guests, esteemed speakers, faculty members, dear participants and students, a very good afternoon to all. It's my proud privilege to propose the vote of thanks for this inaugural session of Conference on Digital Emerging and Exponential Technologies C-Dex 2026. At the outset, I extend a heartfelt gratitude to our Honorable Chief Guest, Professor Dr. C.S. Patil, Director, Kilpar, Bengaluru, for inaugurating the conference and for his insightful inaugural address. Sir, your reflections on evolving relationship between law, governance, emerging technologies have set a thoughtful and inspiring tone for the conference. May I now request Dr. Anirban Chakrabarti, sir, to kindly present a memento to our honorable chief guest as a token of our respect and gratitude. Thank you, sir. We are deeply honored by the gracious presence of our guest of honor, Professor Dr. Harpreet Kaur, Vice Chancellor, National Law University, Jodhpur. Ma'am, your address has enriched this gathering with valuable perspectives and encouragement for academic engagement in emerging domains. Thank you very much, ma'am. I also extend our sincere thanks to our another chief guest, Mr. Karthik Kannappan Saravanan, Global General Counsel and Chief Compliance Officer, Indigene Bangalore. Sir, your address has brought in a much needed industry perspective, especially on governance, compliance, and responsible use of AI in critical sectors. May I now request Ms. Raksha Kaveri, Student Conference Coordinator, C-Dex 26, to kindly present a memento to Mr. Karthik Kannappan Saravanan as a mark of our gratitude and respect. Thank you, Raksha. I express our deep sense of gratitude to our respected principal, Professor Dr. J.M. Mallikarjunaya, sir, for his constant encouragement and for his presidential remarks, which continue to inspire us in our academic endeavors. I also extend my sincere thanks to Ms. Megha Kedia for the warm welcome address and for introducing the distinguished guests, and Ms. Sahitya Pujari for soulful invocation that set a serene beginning to this program. Our thanks are also due to all the dignitaries who joined us for the ceremonial lighting of the lamp, symbolizing the dispelling of ignorance and the pursuit of knowledge. I would like to acknowledge the efforts of our Master of Ceremony, Ms. Raksha Kaveri, for conducting the session so gracefully and efficiently. Thank you, ma'am. I extend my appreciation to all the faculty members, organizing committee members, and student volunteers whose dedicated efforts have made this inaugural session a grand success. Finally, I thank all student participants, delegates, and attendees for being part of this conference and contributing to the academic initiative. Thank you very much.
I request all the